Give it a couple seconds. The Supreme Court is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Good morning, counsels. All counsels are present in the courtroom and justices, and will the clerk please call the case?
This is Supreme Court case number CRA23-015, People of Guam Plaintiff Appellee v. Jared John Santos Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson. Appearing for Defendant Appellant is Attorney Braddock J. Huseman. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Huseman reserves 10 minutes.
You may proceed, Mr. Huseman.
Thank you, Your Honor. Good morning, Mr. Chief Justice, and may it please the court. The government convicted Mr. Santos with the help of the testimony of 3 police officers, and they testified about a partial copy or a full copy, we're not actually sure, of an actual surveillance video. For purposes of the argument today, I'm going to refer to the original as the surveillance video from the mobile gas station, and the copy, the partial or full copy of the surveillance video as the phone copy. The surveillance video and the phone copy were both destroyed. The government failed to subpoena the surveillance video and actively destroyed the phone video. Mr. Santos was never had the opportunity to review either of those videos. 3 years later, after the destruction, the police testified about their recollections of either the surveillance video or the phone video. And that violated the best evidence rule and denied Mr. Santos a fair trial. With my time today, I'd like to discuss 3 things: the best evidence rule in general. Second is why the exceptions to the best evidence rule do not apply in this case. And third, why the admission of the testimony denied Mr. Santos a fair trial.
Before we go into that, let's address the standard of review and the objection, because the government points out that there was not a objection that stated the specific grounds, and by failing to ground the objection and mention the best evidence rule, the objection was not preserved.
Okay, so we don't believe that an objection requires any kind of magic words. That's the standard. It requires the appellate court to be able to fairly construe what the objection was. And in this case, we think there's only one objection it could have been, which is the best evidence rule. There is a discussion about the videos, about the objection to the videos, and it's clear from the discussion this isn't about hearsay or any other exception that I can identify. It is about whether the government can call 3 witnesses to testify about what they saw on videos 3 years prior, and whether that's
my concern, Mr. Huseman, in reference to the manner in which the objection was lodged, is that it did not afford the trial judge the opportunity to determine whether or not the actions of the police officers was done in bad faith. There was a continuing objection, and the evidence was allowed in, and in reference, of course, as you're probably going to address, is whether or not there was bad faith that existed in reference to the police officers, and the video footage at the Agate gas station, whether or not that was destroyed, damaged, not preserved in bad faith. And so, we're now here on review, and by the standard of review here is critical as to which applies, whether the trial judge was not afforded that opportunity, and that's a little that's concerning to me.
Well, I think to answer your question, Your Honor, the fact that there are cross-examination and how there are questions that involve how the videos were destroyed in the first instance, that goes exactly to what the objection was, which is a best evidence rule, because there's no reason to talk about why those videos don't exist anymore and how they were destroyed unless you're developing a record for the best evidence rule, which is why we think the proper standard here is harmless error and not plain error, because the objection is not waived.
Well, that may have been apparent, and that's, I think, what you're articulating, that it's not a hearsay objection. And so because it's the video footage that they were trying to get admitted, that and it didn't exist, that is the only rule of evidence that seemingly was applicable. But even if that was the case, that still does not cure that the trial judge was not afforded the opportunity to determine whether or not, in my mind, I'm more concerning about Officer Camacho's actions rather than the, as you refer to it, as the video footage, the agate mobile gas stations, the way in which the evidence was not retrieved and was erased. And so we're now left with the testimonies in which I am going to resolve in my mind whether Officer Camacho's actions were done just with sloppy police work, negligently, or was it done in bad faith?
Well, and I guess to address that, what I would say is the government is the only party that has the institutional knowledge of this. This was apparently resolved slightly before trial or during the jury selection. I guess we could, if the court is less concerned about it, I would ask for the record to be reopened, and we could hunt down, I guess, the fight over this that they had at the trial court. We don't believe that's necessary in this case, but if the court is concerned, we are, of course, happy to do that to address the court's concern. But I would note that it would be the government's burden to make the record, because they're the ones trying to introduce evidence that they, in fact, destroyed. And the burden shouldn't cut against Mr. Santos in this case, because it is, of course, the government's burden to try to introduce the secondary testimony about evidence that they did, in fact, destroy. And that's why we think that this is we think the objection's clear, and we think that the standard here is harmless. But generally, as to the best evidence, I think this is a rule that allows, or that keeps evidence out of, that is a faulty summary of the actual evidence. The cardinal rule here, I think, is show, don't tell. If the issue is a contract, you show the contract. If the issue here is a video, you show the video. This allows both sides, and you produce it. This allows both sides equal access to the video and discovery, and allows, I think more importantly, the jury to make a conclusion about what they actually saw in the video. There are exceptions for unavailability. The government claims two apply here. I'll go through all four. But the first is that the originals are lost or destroyed, and that the government, in this case, the government, didn't act in bad faith to destroy them. The second, or, is the original cannot be obtained by available judicial process, or one of the parties. I'm sorry, I heard something on the.
No, go ahead.
Okay. One of the parties was charged with producing it, did not produce it, and then they're not able to introduce that evidence, or the video is not closely related to a controlling issue. And the government claims the first and the fourth as exceptions. And we don't think those apply here, which brings me to my second issue, is that there aren't really any exceptions that apply in this context. We'll go through the first that the government claims, is that they didn't destroy the videos in bad faith. But here we think that there's clear evidence of bad faith. The ground rules, I think the parties agree on as far as what constitutes bad faith. Negligence is not bad faith. Destruction pursuant to a policy is not bad faith. To establish bad faith, you need a purposeful destruction of the evidence. And Mr. Santos, I think, can demonstrate that in this case. Here, there are two videos.
We have, the two videos that we have to talk about. The original recording, or what you would call was never in the police's possession, right? I mean, and there was even from mobile to secure safe to have the video. There was correspondence, but apparently it wasn't done. And then you have the destruction of the secondary evidence, the cell phone video that was done.
Correct.
Is there any authority? I want to talk about the secondary evidence that was destroyed, the cell phone video. Is there any authority that addresses destruction, whether destruction of secondary evidence can amount to bad faith?
Well, yes, Your Honor. I think, and
because he could have just testified and not entered the video, right? That would also be the secondary evidence. That was essentially their choice.
Well, I understand that, and I would do it this way, or I would say it this way. I'd make a distinction. First, it's not clear to me that video is secondary evidence. It might be, right? But in the same way, if for example, to use this I'll relate it this way. If there's a contract and I take photos of each page of a contract, and then try and introduce those photos of the contract, and it's clear that those, there's a one-page contract, it's one photo of the contract. I think that counts as, it would satisfy the best evidence rule. I think a photo of a document, a photocopy of a document, even a bad photocopy of a document would satisfy, it would be primary evidence. It would satisfy the best evidence rule. It wouldn't necessarily be second evidence. In this case, we have a video of a video. It very well might be satisfy the best evidence rule in that case. And so I don't know that it's secondary evidence. In this case,
you said that we weren't sure if it was a complete video or not.
Sure.
A complete video.
So
if
I don't
know. It was an incomplete video, would it, I mean, does it qualify as a duplicate under the rules?
Well, if it's an incomplete video, I think then under the rules, there's the parties have to, they'd make that argument. But I would point out under this court's precedent in People v. Tao, right, where you have an edited video, that would be a separate problem, because in Tao there's this video that's edited, but the parties had access to the full video. And it's okay to play an edited video if one side has the ability to play whatever they want to. And then to bring it back to this case, what you have then, if it's a partial video, if the mobile video, if the phone video is a partial video, then we run into the Tao problem where, well, we only have a partial video, and that's a separate problem even from the best evidence rule, I think. And that's an additional problem within the best evidence, or in addition to the best evidence rule. But here we have a situation where the second video is destroyed. It might very well satisfy the best evidence rule, but it's destroyed as well. And the manner in which it was destroyed is purposeful. It was destroyed within, I believe the testimony in the record is that as soon as Mr. Santos was arrested, it was destroyed, and he was indicted, I believe, 10 days after the reported crime. So, and that's 3 years before trial. So we're talking about almost immediately that piece of evidence is deleted. And it's purposeful, and it's not deleted pursuant to any policy of the police department. It is deleted because he deleted it. And we think that's purposeful. We think that qualifies under the statute, or excuse me, the rule. And there's no shelter the government can take for that. As far as the original video, the surveillance video, we think that's also purposeful because the government agent testifies that he's aware that the clock is ticking, that these companies have these destruction policies, and that no one subpoenas anything. And so the government basically allows the time to run out on its ability to subpoena these documents. And I think that is purposeful. We think that satisfies the test when the government knows that these videos aren't going to be available and then doesn't act to secure them. And it's very easy to secure these videos. The government knows how to do it. And we've cited just generic cases as well as Tatao for this proposition that the government knows it's supposed to subpoena this evidence. It knows it's supposed to preserve this evidence, and it just didn't in this case.
Let's say we agree with you and we say, that there was bad faith in the admissibility of in the destruction of the secondary evidence. Why isn't the secondary evidence, the testimony, just cumulative of the testimony provided by the other lay witnesses? So it's harmless error. I mean, their testimony, presumably corroborated the secondary evidence.
And so, Your Honor, okay, so if it's a harmless error test, I think this court in People v. Roten set out the test for harmless error. It's a 4-prong test, the overall strength of the prosecution's case. And here, the prosecution was not able to, and we think of these 4 prongs, 3 of them definitely cut in Mr. Santos's favor. And in our brief, we conceded that there are some issues with the 4th prong. But the first prong is the overall strength of the prosecution's case. And in this case, the prosecution wasn't able to win on its most serious charge. We think the case was kind of close. 2, the prosecutor's conduct with respect to the improperly admitted evidence. And here, we have a situation where the prosecutors know these videos have been deleted. They've got a little bit of a problem in that they've got 3 gentlemen from Agate who are the witnesses to the issue, and they've got to hear that the victim doesn't know my client or the driver. The other witness was able to ID my client and the driver. That was Mr. Paulus, I believe. And then there's a Mr. Henry who wasn't able to identify either of the individuals, but I think subsequently did identify them in a lineup. But so the government has 3 witnesses that have some gaps in their knowledge and their gaps to relay the government's theory of this case. And the government plugs that hole with 3, they bolster that testimony with 3 police officers testifying about what they watched on a video. And so we think the prosecution needed this, or wanted this, and it was important to the prosecution. So we think we satisfy that prong as well. And then the importance of this wrongly admitted evidence, like I said, I think it's a bit of a conflation there, but the government called 3 police officers to testify about the video and what they saw on the video. And we think that speaks as to what weight the government gave it and how important that evidence was to the government. Now, to your point, Your Honor, I think that there is some evidence, there is independent evidence of, there's an ID of my client by one of the witnesses as the shooter. So there's a possibility of that being somewhat duplicative. But again, what we think here is that there were some problems with the government's case and that they use this evidence to bolster, and it helps their narrative. It gives them a motive and helps explain what happened that night in the government's terms. And the admission of 3 police officers basically to bolster the gentleman from Agate's testimony, we think was not harmless, to answer if that answers the court's question.
I have
But
one more question
Sure.
about the original video. You seem to allege, although it's not clear to me, that the video footage might have been exculpatory. In what respect are you asserting that the video would have been exculpatory?
Okay, so I haven't seen the video and I am not alleging that it's exculpatory. I don't know that it's exculpatory. And if that is if the court took that as an allegation on my part, it is not. And I apologize for any misunderstanding.
It just came out in the brief, so I was curious. It said that you were unable to review it for the exculpatory evidence. So I was trying to understand what might have been exculpatory on the video.
And my only point about that is the evidence doesn't exist, right? So in People v. Tatao, the evidence exists, and if there is something that the party wants to use, they can. And I think in Tatao they didn't, right? There wasn't anything exculpatory. In this case, nobody knows because the evidence was destroyed. And when you look at this, you've got the government calling 3 witnesses to testify about what they remember from watching the video. These are police officers. Their job isn't to find exculpatory evidence, it's to find inculpatory evidence. And so it's a one-sided affair, and it all hinges on the fact that the government allowed these videos, either allowed them to be destroyed, allowed the clock to run out on the destruction, or they purposely destroyed them. And I know I can see that I'm coming close to my time.
Before you before you yield to Mr.
Sure.
Tennyson, when you use the word purposeful, backing up a bit, the assertion is that the police officers, again, their sloppy police work may have been negligent, but it was not in bad faith. So in taking into account how you determine or whether or not the actions of the officers amounted to bad faith, you're using the word purposeful. And I'm thinking of it in the way of as, was it intentional or was it reckless? Maybe they didn't do it intentionally. But if they did not, Officer Camacho did not check whether or not there was a retrieval of the video surveillance footage before he erased his phone recording, negligent, possibly, intentional. But, if the standard is also reckless, maybe that is something that may be more applicable in the facts of this case. So purposeful is a little vague to me in reference to the standards of how we determine, or how I determine in my mind, whether or not there was a bad faith conduct on the part of Officer Camacho.
So if I take the court's point, I would respond this way. I was like, the reason we use the term purposeful is that it's a term that we found in a federal case that outlines Guam's as the identical best evidence rule, GRE 1004 as opposed to FRE 1004. And so I don't have the case in my mind up front, but the holding was that it's purposeful when the government takes that initiative to destroy the evidence. And in this case, the reason we say purposeful and I don't think it needs to be malicious on the part of the on the government, although it could be. I don't think we need to satisfy a malicious idea. When you use bad faith, And this is why we think it satisfies. So with the surveillance video, the government knows that the clock is ticking down. They know that, and I think this is in ER 125, that they have a narrowing window to subpoena these records, and they just don't do it. And we think that's purposeful. We think that purposeful can be implied from that. We think bad faith can be applied from that, because you can call that sloppy, and you can even, and I know the government calls it negligence, but I would say this about negligence. Negligence is their mistakes, and generally mistakes run. Sometimes you benefit from a mistake, sometimes you don't benefit from a mistake, and it ends up biting you. And here the mistakes all seem to run in the government's favor, which is why we say it's purposeful. So they just don't get around to subpoenaing, and the document gets, the surveillance video gets destroyed. But as far as the phone video that was destroyed, that's an obvious purposeful destruction. The government knows it has, or the agent knows it has this piece of evidence, and decides that he doesn't need it anymore, and he just deletes it. Again, I don't think that has.
Yeah, something relating to this that's, and again, it goes to my original comments and goes to the specificity of the objection on the part of defense counsel, and as a result of not specifying the specific objection of the violation of the best evidence rule, it denied the trial court the opportunity to examine the conduct of the police officers as to whether or not you describe it as purposeful. And in my mind, I'm looking at the continuum: negligent, intentional, reckless. And my understanding of the case law is that intentional, reckless is part of the examination as to whether or not the conduct was in destroying the evidence was in bad faith. And it, as a result of the non-specificity of the basis of the objection, that raises concerns in my mind, and the proper examination, something for us to review on the record in reference to the lack of an examination of the bad faith issue. That is, as you have pointed out, one of the exceptions in reference to the admission of the secondary evidence.
I take your point, Your Honor, and like I said, if the court, I can always try and find the section of the trial. I assume it isn't a trial transcript of the. I think it probably happened during the jury selection, and even though I think my client's trial counsel asked for all the trial transcripts, I think the practice is not to provide the jury voir dire. And so we can always ask the court to, or I can move to have that, I can search for it and have it moved. That might address it. But again, I would say that it's the government's evidence, it's the government's burden. And as far as recklessness goes, here there's an obvious problem with the deletion, the actual physical deletion of the phone video, but also of the running out of the clock on the subpoena time. The government knows how to subpoena, knows it's supposed to subpoena, knows how to do these things, and just didn't do it. And when you combine those two, it really does become a problem. I see I only have 2 minutes left, so I'd like to reserve that time for rebuttal.
Thank you, Mr. Huseman.
Thank you, Mr. Huseman. Mr. Tennyson?
Thank you, Your Honor. May it please the court, Chief Justice. A couple issues the people would like to address. At the offset, I would say the testimony regarding the video, 3 officers did testify, but they testified as to other situations and issues. It wasn't just bringing them up to talk about this video. A lot of them did other things in the course of their investigation, and I believe 2 of them may have seen the video. Mr. Jayobo testified to, manager of the mobile station, saw the video, testified several years later as to what he recalled, and all the testimonies, I mean, kind of line up. Even Mr. Jayobo's. And we'd raised the standard of review issue. I mean, a real concern here is, you know, if the objection is obvious, if the substance of it is obvious, the court can address it, you know, if it needs to take evidence, if it needs to hear argument, the parties can be heard. In this case, I mean, the record, there's a continuing objection. There's never been a formal objection. The judge invites defense counsel, please, you know, make an objection. And for this video, it didn't just become a hot topic at trial. It was a hot topic throughout the proceedings. I would have expected counsel to have a, you know, GRE 1004 citation, as opposed to just we have a continuous objection on this issue. Because I mean, I look at it and I appreciate the defense's position that this seems like a pretty clear original document, you know, original evidence issue. In the midst of things, I'm not exactly sure, you know, could it not be relevance, foundation, hearsay? Well, there's lots of reasons why people might object, and particularly for original document, there's a series of elements that need to be looked at. And, you know, the people have kind of looked at the record after the fact and tried to point out, well, here's evidence of this element, here's elements of that. Judge took these under consideration, and that was a basis for admitting it. Was it ever specifically ruled on? No. And it does need to be raised for that purpose.
What about the burden of proof? Is it up to the proponent to establish that the originals were lost and this was not the result of bad faith?
I believe so. So the rules really kick in because it says the original is not required, or rather, a duplicate is admissible to the same extent as the original unless someone objects to the
authenticity issue.
The authenticity of the original, yes. Yeah. So originally, proponent says, "Here's, you know, we don't have an original. Here's a duplicate," and then responding party would object, not the original. We object because of authenticity reasons, and then it's the proponent's job to go in and say, "Well, here's why we need the duplicate." And as we hit the 4 elements of 1004, lost or destroyed, not obtainable through process, in possession of the opponent, won't turn it over, or it involves a collateral matter. And as part of that, destruction or loss, you know, there's a split in the jurisdictions. I think I saw in my research into the situation, kind of the most strict is, you know, looking at this bad faith motive. Was it destroyed in bad faith, which is to gain an unfair advantage, to prevent the other side from having it? There are other jurisdictions, I think Arizona's one, with more of a liberal approach to this and saying, well, if the government had custody, even if it was destroyed in the course of business, there's a case, I don't remember the name, out of Arizona, the Tucson Police Department had interview records, a video of a defendant who had been, or a victim, and it had been destroyed just due to age. Several years had passed, it was destroyed. And Arizona Supreme Court said, despite the fact you destroyed it according to your retention policy, you have prevented the defendant from having it, and we're going to presume that the evidence was in his favor because of that loss. But this ties into original document. I think the people's contention here is the probative value of what was in the video, or what's alleged to be in the video, because only 3 people have seen it, doesn't seem to be earth-shattering, even according to Mr. Jayobo's testimony, who I give the most weight. If he had seen something prejudicial or really remembered, but he says it was grainy, I couldn't identify anyone, a car came, another car came, they both left. And there may have been a discussion or something of the vehicle. It's really been more of and this is the serious issue in this case. I wasn't the original obtained. There's been discussion of Officer his name's on the tip of my tongue.
Camacho.
Thank you. Who had the copy on his phone. Now, when I look at the tier of evidence of someone seeing the video, testifying as to its contents, and someone having a cell phone recording a facsimile of the original, for purposes of 1004 and 1003, I view those as the same tier of evidence because they're copies. Now, am I going to give a little more weight to the video copy? Yes, because I can see it. I trust my eyes, whether that's wise or not. Now, where the issue becomes is, had the video not had any useful information, it probably would have just, the duplicate, the copy on the cell phone would have been admitted. Had it been exculpatory, I'm sure the people might have tried to challenge it. I don't think that would have been successful. Had it been prejudicial to the defense, I think we'd still be here talking about how the cell phone copy was an inadmissible duplicate. And the original is more than just the contents. I mean, if we have a scan of a will, that's one thing. It contains all the terms of the contract or the will or the document. But when we're talking about video and even digital records in general, it's more than just the contents. It's the metadata. What if Officer Camacho, the video is testified to be in color. What if he had recorded with a filter that was in monochrome and the duplicate was in monochrome and no one could tell because no one had seen the original? So there are concerns about even this facsimile copy. Even that has to be given a little less weight. And to the extent that these should be weighed in certain ways because they aren't the original, they're duplicates, they're almost hearsay in a way. They get weighed less. They get less value when we look at them. And to that extent, bringing in multiple police officers, Mr. J. Oba, to testify as of the video, those were also sources that the defendant had to cross to challenge and say, well, this recollection doesn't match this, or did you really see this in the video? They could have questioned the memory, the reliability, and played these witnesses against each other. But generally, and defense counsel did ask questions of these witnesses as to what they saw in the video and in the actual events. The testimonies were generally the same, which I think leads to, regardless of the standard of review, if we're using harmless error, if we're abuse of discretion, if we're using plain error, I don't think as we assume there was an error in admission of this, that the trial court heard, and I think it's within their, this is a reasonable discretion thing. Was that evidence prejudicial? And I think with all the other evidence, the footage captured, they were both at the mobile and they departed. And even then it's speculative, the details, there's no license plate. No one says, oh yes, it was license plate, whatever. It was a blue car and a yellow car, of which there was disagreement as to the make and model. So the shooting isn't implicated. And that's why we say it's collateral. This isn't, even without the video, even without the surveillance, the discussion of it, there is still sufficient for the jury to have heard evidence and to find as it did. They didn't rule this way because of the video, because the video doesn't have anything dispositive in it. And this isn't to argue against the value of having these kinds of records subpoenaed, seized, in custody. When I look at the motive here, and this ties into raising it with the trial court, is what was the delay? All the people can do is speculate as to, well, who was at fault? What was the basis of the fault? Was it negligence? From what I've seen, the most I can determine is negligence of one or multiples of three parties: the police department, mobile agate, or secure safe. Possibly all three, possibly one of them. It seems like everyone from the record, and the court had a sufficient record to look at this, was saying, well, we didn't have it because of this. I talked to so-and-so, they never followed up, and it was destroyed.
Well, what about to Mr. Huseman's point? Because you're saying that under whatever standard applies here, whether it's plain, harmless, the video did not add to the, or was not substantial evidence in relation to the issue of who is the shooter, who is responsible. But what about as to Mr. Huseman's point? This is a jury trial. There were 3 police officers who testified as to what they saw in the video. And so there was a seemingly implication that there must have been something important in those videos if there was so much focus, and the fact that it was destroyed, and there was it was not produced. Wouldn't there be some kind of implication in the minds of the jury that there was something important in this videos that may have been may have contained evidence in reference to the who is responsible, or in terms of the shooting?
I think that's a good and fair question, and I think there could be. So this is an interesting idea, because I've been thinking about this on this case, is the value of this issue, this evidence, and I think that issue would have been raised with the jury by either side. I mean, as I've looked at it, I feel like the defendant has also used this as a method of saying, well, there's been impropriety, there's been sloppiness, there's been these kind of systemic issues that have really deprived me of having this video that I can look at that may have been exculpatory, maybe not, we don't know what's in it, but it could have been. And I was deprived of that. And that's a good point. And I think that's worthy of looking at. I think the concern is, as it's been raised in this case, is this has never really been about the contents of the video. It's been about, well, no, there's nothing on it. We weren't trying to hide anything, and here's people that saw it to say that there was nothing there. Because otherwise, there does become this presumption of, well, why did the government destroy it? Why isn't it here? When that issue is raised by the defense. So I've kind of viewed it from that perspective of, it's not that the video was destroyed in bad faith, and that it's that it was destroyed negligently, and now there's this, well, we should have this video and we don't, and we should be talking about it because defense is talking about it. My hope would be when the jury sees, or here's the testimony about the contents, they hear it and they say, is that all? Or they say, how does this compare to what I heard from someone who was there, a lay witness, who saw the events? Does this serve to impeach them? Does it back up what they said? I would hope that the jury has the ability to weigh the evidence, to look at it, it's a duplicate, and to weigh it accordingly that way. That would be my response. I mean, the underlying situation, of course, the people in the government would prefer to have the original. In this case, we don't. And without developing that record below, we couldn't have brought the police in, SecureSafe and Agate Mobile, and said, what happened? Where's the video? I mean, really a chain of who contacted whom, when, who didn't follow up, who did, and who dropped the ball. I mean, at the end of the day, I would hope that government checks, follows up, but also there's other extenuating circumstances that could be in the record that aren't, I don't know the basis of what happened. There could be bad faith. There could not be bad faith. It could be negligent. It could just be overwork. We thought someone followed up. They didn't. Is that the best excuse? No. Is it bad faith? No. Now, if you were in Arizona and it was destroyed and the government held it, that's the thing, is government custody. I mean, even we talk about this duplicate, the phone, the cell recording, it's not an original, it's a duplicate. And I haven't seen anything that what we're really talking about is it a fair representation of the original?
But
that's what it comes down to.
In my mind, similar to my comments to Mr. Huseman, Mr. Tennyson, when you just, generally describe it as a bad faith, I think the probe is a little deeper. Was it intentional? Okay, questionable. Was it reckless? So now that I start to have a little more doubts, or in reference to the negligence end of the spectrum. But was it reckless? How experienced was Officer Camacho? You know, what was his practice in reference to before he completes his investigation? That, you know, does he go back and check and make sure that all the evidence that is going to be used to support the accusation have been retrieved and is in place before I delete an evidence that is potentially very important in the case. And so recklessness is something more relevant in my mind. That is relevant to determine whether it's this bad faith. Just glossing it over says, was it bad faith? No, it wasn't bad faith. You know, it may have been negligent. Okay. But I think it goes a little deeper than that.
Yes. And I think that's a good avenue to be looking at. You know, I don't want to cast or apportion more blame than I can look in the record and say. Now, if there were some factors that indicated bad faith, and I think at this point we're in a realm of reasonable minds can differ. I appreciate that people could look at the situation and intuit recklessness and see that as bad faith. And I'd be open to a perspective of that with more information that I've seen that draws me to that conclusion. From what I've seen, I mean, I don't want to go beyond the facts I've seen, and that's why I don't want to go into saying, is it reckless? Is that a determination the court can make? Yes. I mean, you have the record before you. You're reasonable as well. You can look and make that determination. I look at it without saying more. I say negligence. Now, and here's the thing: is if we look at different standards, if we look at Arizona, regardless of if it's bad faith, negligent, reckless, good faith, destruction, pursuant to a policy, there's still a presumption against you, and the solution there can be the presumption in that evidence. What it comes down to is, what do we see the due process need in addressing this kind of lapse of availability of evidence that the government has in custody, or perhaps in this case should have in custody? Now, insofar as it's an should have in custody case, that doesn't, you know, that's not within this 1004 rule. If we're briefing and discussing the original document, the government's never had custody of the original document. Now we can talk about whether they should have. Was there failure to grab it? What was the intent? What was the basis? Was it negligent, reckless? But that brings us under a different rule or standard, and I'm not sure what that would be articulated as. You know, and maybe that has been part of the issue at the trial court as well, is the difficulty of articulating the concern over the underlying substantive issue, and it manifests itself as this kind of 1004 issue, or a general evidence issue. Really, can you just argue how it was presently brought up? And under the 1004 evidence, I don't think the standard's been met. I don't think the trial court was unreasonable when it looked at, well, one, didn't receive a firm objection as to what it was examining, but beyond even a plain error, I think there's a reasonable basis here the trial court relied on to say, I've weighed it, and the judge even weighing it, they're just looking at, does this seem to be, you know, I don't say necessarily reliable, but a copy of the original that can be used. And then the jury weighs it if it gets put in. And how the jury comes away from that. That one, I don't know. I mean, I know how they found here, but just without more in that vein, I just think the record is limited to making broader determinations as to the motive, the reasoning behind it. And I don't think those are necessary to reach the 1004 answer. Let me, and I forgot to hit my time to track myself. I don't know if the clock is on here. Oh, it is. Excellent. Thank you. Let me look through my notes really quick to.
Let me ask the question about, you know, the 1004 which is the collateral matters, because under I mean, we've been addressing mostly the admissibility if the originals lost or destroyed and the proponent hasn't destroyed them in bad faith. But one of the other arguments was that the video wasn't closely related to a controlling issue in this case. But I mean, it's not so tangential, it seems, to the actual controversy that, I mean, why would it have no outcome, impact on the outcome, this video? I mean, you had 3 people testifying about it.
I think yes, I agree. That's a fair point. I think in the midst of looking through arguments, looking at transcripts, you kind of look at the legal issues and, oh, this seems like a more of a collateral issue. However, it's not necessarily that collateral, is it closely related to? And they were both at the mobile agate. There was discussion about it through other witnesses. And it did precede the shooting. When I raised that point, I was thinking more, it's not, it doesn't make the shooting more or less likely from what I've heard of what's in the video. What makes the shooting more or less likely and who did it was the testimony of other people. And then, well, the videos, well, according to the video, well, both the cars were there. That proves they were there. Is that enough to, from then jump and say, and therefore that was the blue car that was involved in the shooting? Not without the other testimony, but no, I would concede that it is related in that sense. I would just request that the court weigh it more. I think also it was raised as the level of the error or the harm of if it was improperly admitted, if the judge did abuse discretion in allowing that testimony, what the actual harm was. And in that sense, the contents of the video weren't as dispositive as other testimony.
I have a question, Mr.
Yes.
Tennis.
Chairman?
The defendant has asked for retrial as a remedy. Is it necessary for the court to order a retrial on the possession of the firearm conviction? Or does that stand alone without?
I think I would, of course, like to give this more time of consideration. Off the top of my head, I would think it does not. I mean, I would want to review the record again to see the chain of events, but I believe the firearm was located during investigation. I don't believe the video was implicated in locating anyone. I believe that was done through the other witnesses. Now, I don't know how that charge might be impacted by the other charge in that sequence of events, and that would be my main hesitance without analyzing that issue. That's a good question. I can't give you a more definitive answer without looking at the record. I apologize.
Okay, thank you.
Covered that. Really covered the main issues that the government wanted to address. I mean, substantively, we're looking at really, if I wish it had been developed more in the trial court and there was more to work with, because then you can look at intent and you can look at other things. And the trial court would have had the opportunity to hear these issues too and could have initiated its own evidentiary hearings, findings if it felt necessary. Without that, and I'm not exactly I don't think a remand would help with that either. And I'm not in favor of the remand just because I think at the end of the day, the video isn't. I think it's harmless error. We've explained why. We've argued why in the brief. I would rely on that. There are cases where this issue should be dug into. I'm not of the opinion that this is one that will lead to a result that will cure the underlying concern the court is looking at. And for that reason, I'd request this court find the trial judge didn't err, that the admission was appropriate, and uphold the trial court and the conviction.
Just one question. So by you saying that you believe the error was harmless, so you concede that there was a harmless error standard of review as opposed to a plain error standard of review, that there was
I would still say it's
objection.
plain out. I would still say it's plain error. I'm arguing under the higher standard. I mean, plain error. I mean, if you found there was error, you could even under plain error, if it was obvious, go in and I'm not sure it's obvious from the record below. Maybe it is. That's not, that's a determination for this court. I'm just saying, if we're looking at harmless error, if we're looking at that standard, I don't think
there's no substantial prejudice is what you may
yes, that's what I mean.
even though.
Thank you for clarifying. That's what I meant. There's no substantial prejudice from the testimony regarding the video. But that's a determination for the court ultimately. It's just our position.
Thank you, Mr. Tennyson.
Thank you.
Thank you, Mr. Tennyson. Mr. Huseman has, I think, 6 minutes or 5 minutes. How much time, Mr. Huseman, have left? 1:40. We'll give you 2 minutes, Mr. Huseman. I guess it was 6 minutes before that final question came in.
May I ask my question first?
Yes.
I will ask you the same thing I asked Mr. Tennyson. Do you believe the court needs to vacate? I assume you're asking for a new trial on both charges, but is it really necessary for a new trial to be on the charge of possession of a firearm without a valid ID? I'm sorry,
You're muted, Mr. Huseman.
Sorry about that. Thank you, Your Honor. Candidly, if the court wants additional briefing, I'm happy to provide it. But I think that I would have to say that the firearm, one, I don't believe the firearm, the government wasn't able to tie that firearm to any crime aside from without the proper identification. I think it occurred after the fact. So I don't know that it's necessary to remand on that issue on the issue we brought before the court. I don't know that's needed, but that would be my answer. But I'm happy to brief the issue. I'm a bit hesitant as well because it is a good question. I hadn't really thought about it, so I'll leave that up to the court if it wants additional briefing. As far as my rebuttal, I want to hit a few things. First of all, as far as the collateral issue, because I don't really think we got to that on mine. Whether it's a controlling issue or a collateral issue, I think is nebulous, but fairly clear here. The example that's used in the best evidence rule is that of you don't need, for example, if there's an attorney who's appearing as an expert witness, they don't need to provide their bar license under the best evidence rule. If that individual is being rung up on charges of practicing law without a license, then they're going to need to provide that the license and not just testify that they have a license. And in the same way here, we don't think this is collateral. We think this goes to the government's theory of its case. It provides a motive. It provides an explanation. The video does of why these things happened in the government's theory of the case. And so and this goes back to if the testimony about the video isn't important and it's not needed and it's just there for filler, there's no reason for the filler. But they called them anyway. So I know the government now says this wasn't important and there wasn't really an issue, but again, they called a lot of witnesses to tell the jury exactly what happened on the video. And I think it's more important to rely on what the government said its case was about as to what it claims the case was about now. I don't think with the government's answers that there's a limiting principle here. We have a government agent that knew that there was a deadline, allowed that deadline to expire, and also destroyed evidence that he had in his possession. And with regards to whether it's a copy or a full copy, I think that brings the case more under Tao, which is, look, if we're going to put in evidence, both sides need to see what the evidence is and to say that the defendant in this case didn't have enough time, had the ability to cross-examine. Well, sure, they have the ability to cross-examine and ask questions, but they don't have the ability to see the video to ask an appropriate question because the government destroyed the video. And there isn't a limiting principle here. So I see my time's expired, but we're asking this court to affirm its precedent that it said in Tao. A defendant needs the opportunity to have full access to the government's evidence. If the government is going to destroy that evidence, admitting testimony about that destroyed evidence is not harmless error. The judgment should be reversed, and this case be remanded for a new trial.
Thank you, Mr. Huseman. Thank you, Mr. Tennyson. The court will take the matter under advisement. We'll issue a written opinion and will now stand adjourned.
Thank you, Your Honor.
Thank you. Your
Bye-bye.
Honor.